I had the opportunity to read your book before it came out. That's a rare and wonderful gift, particularly when it comes to this book. I guess I want to start by asking you to share with those in the room what happened the night of September 17th, 1998.
Well, that night in East Houston, in Texas, there was a call to the Harris County Sheriff's Office that there was a dispute or a potential dispute in an apartment, a private apartment, where there was a black man who was said to be going crazy with a gun. The Harris County Sheriff's Office then came to the apartment, and the officers found the person who reported that this disturbance was going on, was directed up to the apartment by this person. They went upstairs, and they said they entered the apartment, conducted a brief search of the apartment, made their way into the very back bedroom eventually, and 2 of the 4 police officers who were initially there reported that they found the 2 men who were in the apartment having sex. And they said that this violated Texas law that forbade homosexual conduct law. It's titled the Homosexual Conduct Law in Texas. And it forbade certain sexual acts if performed between 2 people of the same sex. They did not find the gun. That turns out to have been a false report, but they did say that they had seen this violation, which was a violation wherever it occurred, whether in public or private, and cited the 2 men for violating the law and took them to jail where they spent the night. And they got in contact with their lawyers and challenged the constitutionality of the law. That is the way that the story is usually described. I think it's a lot more complex than that, and I think there is significant reason to doubt the version of the story told, at least by the police officers. And so part of my book is about unraveling the mystery of what happened that night.
Who were these men? Tell us something about the men who were arrested and who later had their names attached to a Supreme Court case.
One of them was a white man named John Lawrence, who...
Can folks hear okay in the back there? Okay, good, thanks.
A white man named John Lawrence, who was 55 in 1998 when these arrests occurred. He was from southeastern Texas. He served in the Navy and then went on to become a medical technologist and was living in this apartment complex for, at that point, about 20 years. The other man was a man named Tyrone Garner, who was a black man, who was the 10th child of a family, a Baptist family in Houston. He grew up very poor. Neither of them had much in the way of worldly possessions. Tyrone Garner, for his part, never owned a home, never owned a car, moved about from place to place, from apartment to apartment, and was in trouble, as both of them had been on various occasions with the law, DUIs, things like that. And they had a mutual friend named Robert Eubanks, who was Tyrone Garner's partner at the time, and John Lawrence's friend. So they came to the case with no record of any kind of activism in civil rights or gay civil rights. They were just leading their lives in this East Harris County apartment, and that's when they encountered the police.
And when you said the arresting officers that night, 2 of them said that they were having sex, what did they say? What did the other 2 officers say?
Well, would you like the most salacious version of what the police
officer said? Well, I know all the other media opportunities that you're having, that's what they're asking for. So sure, let's go ahead and do the salacious first.
We'll do that part
and then we'll proceed into more of the legal ramifications of the whole thing.
So one of the police officers said that they knocked on the apartment door when they went up the steps, looking for a man going crazy with a gun, which they honestly believed was happening. So it's a dangerous situation. It's a very serious situation for any police officer. It's a serious situation for citizens, anyone who might be in there. They had their guns drawn as they went up. The lead police officer who arrived first, a man named Quinn, Joseph Quinn, knocks on the door, announced twice in a very loud voice into the apartment that it was the Harris County Sheriff's Office. The knocking on the door had the effect of pushing it open so they could see into a living room area right there at the front. No one, they said, was present. There was no television on, they said. There was no radio on. There were no sounds. The apartment was quiet. And the four of them, in a tactical stack, one right behind the other, entered the apartment. Two of them went off to a left bedroom. Two of them, including Quinn, who had knocked on the door, went forward into the apartment and saw a man, they said, talking on the telephone next to the refrigerator. So they frisked him to make sure he didn't have a gun, told him to drop the receiver and so forth, which he complied with these police officers with their guns
Just
drawn.
walk in, yeah.
And they secured him, and then the two of them saw that there was another bedroom door open, slightly open, with the light off inside. So they slowly approached this door. They reached the threshold of the door, and one of the police officers reaches the threshold and says, in the shadows and in the dark, toward the back of the room, he could see two men having sex, which startled him. So he lurched back, to use his words, and the officer behind him, Joe Quinn, the one who knocked at the door, figured he must have seen the person with the gun. So he said he went around low on the other officer's side and kind of in a crouched position with his gun pointed straight ahead, looks into the apartment where he says he saw the two men engaged in sex on the bed. And when he realized what it was, he said that he told them to stop what they were doing repeatedly. And he said that John Lawrence, who was the older man in the apartment, the 55-year-old, looked at him eye to eye and then turned back and continued what he was doing. Then he said they turned on the light in the apartment and repeatedly, with their guns pointed at these two men, told them to stop having sex, which they would not do. And he said that this went on for well in excess of 1 minute. Now, we could stop here for just a minute and think about
what stamina, for one thing, that would require to...
I had several people among the personnel in the Harris County judicial system say that they believe that the moment would have been over and that there aren't enough pharmaceuticals in the world
that would mean,
to make all of that possible. So he said that ultimately they would not stop, and he had to pry them apart to get them to stop. And that's the story that one of the officers tells. Now, when I interviewed these officers for the book to ask them more about it, by that point, and it was a few years after the case, but by that point, they no longer agreed on what kind of sex they had seen. They just knew it was two men, and whatever they were doing, it violated the Texas homosexual conduct law. And it turns out the men denied the police version of events. So that's that's the police officer's version. Now, he doesn't tell this whole tale in his police report filed that night. All that he said in a 69, 70 word complaint was that we were called to this apartment on a weapons disturbance. We entered the apartment, whereupon we saw two men engaged in sex in violation of the Texas law, and we arrested them and brought them back, and that's it. And that's all that the courts were told going up. So my book was a more detailed version of that story, which to me did not make a lot of sense on its face. And then I also eventually got a version from one of the two men who were arrested.
So the four officers, two said they saw sex of some kind, not even agreeing which one, what kind of sex, and then the two other officers did not.
They didn't see anything.
They were further back.
We didn't see anything. We were back in the apartment.
Yeah.
We were looking in the other bedroom. We were securing the man who had been on the telephone talking to someone, and we didn't see anything. So two of the four officers said they saw something, and they disagree about what they saw.
So John Lawrence and Tyrone Garner were arrested.
Correct.
And what happened next?
Well, that's several chapters in the book happened next. I mean, they went to jail that night where they were booked. I mean, they went through and answered all of the standard intake questions. They were given orange jumpsuits, which you wear in the Harris County system. And then they were told, go take a shower together. And they went and did that. And they were given mattresses to sleep on for the night, and they spent the night in these jail cells separately. John Lawrence asked to be in the gay tank, which was a separate area for the gay prisoners who were subject to taunting and ridiculing and harassment and sometimes physical violence. And Tyrone Garner spent the night with the rest of the prisoners, mostly people who were intoxicated, taken off the streets, and minor scuffles and things like that.
Yeah.
They let it rest there, and that's where it would have stayed. I mean, it was a $200 Class C misdemeanor in Texas, the equivalent of a speeding ticket. And since they had no connections to the gay rights movement, there was no reason to believe that they would end up anywhere with this case, that it would just stay there. They'd either pay their fines, or they might go in and try to convince a judge that they didn't do it, but they couldn't be expected to challenge the arrest and take it to the Supreme Court. There's no sodomy arrest alert that goes out to all of the gay rights activists in
Really?
Houston.
Because I thought there was like this special system now to...
No,
okay.
The gay agenda never got around to the alert
to setting
system.
up that, okay.
And it's an accident that gay rights lawyers even found out about it.
Because these two men who really were not socially powerful and not
money.
Connected to activism in any kind of way.
Not connected. No, that's exactly
And I think, as
right.
you wrote in the book, most of the time when this happened, which wasn't very often, this was not something that people were arrested for that much, and we can talk about that.
Right.
Most people would have paid their fine, gone home, probably been pretty embarrassed and not wanted to talk about it again.
That's exactly right. And the only reason that didn't happen, I'm convinced in this case, is that John Lawrence's apartment happened to be in the jurisdiction of a justice of the peace in Harris County who had a clerk who was a closeted gay man. And he saw the report come in when he got to the office the next morning that there had been this arrest for sodomy, and he knew the reputation of the officer who had arrested them.
Okay.
And he said, this is very funny. He had no code to enter this, just in the administrative system of the court. They didn't even have a code for this.
Because it wasn't happening often enough
It wasn't happening.
For the arrest.
Right. I mean, a burglary or even a murder, a sexual assault or something, you'd know and you'd have a code. He didn't even have that. And it might have stayed there because he didn't recognize the importance and the potential constitutional significance of it, except that he had a partner who was also a closeted sheriff in the sheriff's office who had heard about the case. And every Friday night, they would go to the local gay watering hole and just kind of gossip with the bartender who was there. And so the next night, they show up at this bar, and they're just having conversation about whatever, and they mentioned, we got this arrest report that has come in, and it's so unusual. And the bartender happened to be a gay activist in Houston. He had a dual role. He was a bartender and a gay activist.
Kind of a day job, and then
then the rest, exactly.
His passion.
Right, exactly. And so then when he heard it, he realized there was something here. This was the case that you had been looking for, because you could never, people were not arrested under these circumstances. Adults in the privacy of a home and as charged by the police. So he then connected with attorneys who eventually got it to land illegal in New York.
Well, that's one of the things that I found so interesting in the book, that the portraits that you draw of John Lawrence and Tyrone Garner, and also of the arresting officers, Quinn and Lilly, and the other two fellows whose names escape me at the moment. But you really develop these characters the way a novelist would, really. I mean, very rich and complex people, likable, dislikable, all at once, But also what struck me as another character in the book is kind of 1980s Houston, 1990s Houston, kind of the Houston social political gay scene that was part of the sort of fabric out of which this was, what made this possible. tell us about 1980s Houston, kind of the rise and fall, and what it produced that allowed there to be somebody who could
Right.
pick up this case and run with it.
Right. So one of the, as you note, one of the parts of this book is an attempt to place it in a historical context.
Yeah.
It didn't just happen.
Yeah.
It was in part a product of what I believe was an abusive arrest and a false arrest.
And make sure you keep addressing the folks in the back row. Yeah.
And in part, it was a product of a movement that was in Houston and in Texas. Mm-hmm. And so in the 1980s in Houston, gay advocates for the first time had begun organizing politically, had begun supporting candidates for office, and had succeeded in getting supportive, they believed, candidates elected to mayor and to the city council. And their efforts were met with opposition. And one of the examples of this was that they got a civil rights ordinance passed in Houston in the summer of 1984 that protected city employees from discrimination based on sexual orientation. That is, protected city employees only from being fired or being demoted for being gay. And that provoked a backlash from some people in Houston, political conservatives, religious and social conservatives, who saw efforts like that as leading ultimately to a wider societal decline and decay, disintegration. And there was a referendum placed on the ballot in that fall, voted on in January 1985, to repeal that protection, which probably protected, we're talking about 10 people in the city of Houston.
From who worked for local government.
Worked for the city in specific roles, and only in this way, and it specifically forbade quotas and so on. Very limited. And it was subject to this referendum. That referendum campaign played on every single stereotype of gay men and lesbians. That they were trying to recruit children, that they were predatory toward children, that they were infiltrating the police office, the police department, that they were attempting to cause a kind of decay in our society over time, and it was dangerous. There were amazing statements made. People came forward and advocated quarantining all homosexuals during this referendum on an ordinance that protected 10 people from discrimination on the job. And when that came up for a vote in January of 1985, the ordinance was repealed by a vote of a margin of 4-1. So in Houston, Texas in 1985, it was beyond the pale to protect people from discrimination in this role. And it had an effect over time. And the movement, gay rights advocates, realized this was not going to be a short battle. It was not going to be an easy battle. And they had better get organized politically. They had better get organized legally, and needed to be vigilant. In addition to that, in tandem with that, there were attempts to challenge the constitutionality of the Texas homosexual conduct law in the courts, and there were efforts to have the law repealed in the legislature. And those efforts were repeatedly failed in the legislature because the legislature did not even want to touch this issue, believing that there was nothing in it for them and that they would face some retaliation of their own politically. And on the legal side, it failed repeatedly because the police were not going into homes and arresting people. And instead, these laws were used as a pretext for discriminating against gay men and lesbians in every area of life. Yeah. It's not that anybody was being arrested, it's that when you went to get a job at the police department said, we can't have someone in the role of law enforcer who is an acknowledged law violator. It's when you went to get a job as a teacher that the school said, even though you haven't been convicted of anything, you're a bad role model for our kids. It's when you tried to adopt children or to raise your own children that the state objected on the grounds that you would be a corrupting influence. It's when you tried to rent an apartment from a landlord that the landlord said, I don't want criminals living in my apartment building or in a room in my home. In every area of the law it had an effect, but no one was being arrested.
That was one of the things that really your book helped me to understand that, how sodomy laws help to criminalize a class of people, not so
Right.
much to criminalize a behavior, although that was what the law was about, but anyone who could be suspected of that activity
That's right.
was then treated differently.
That's exactly right. It was titled the Homosexual Conduct Law. And if you read the law, it doesn't say gay persons are illegal. It doesn't say gay persons should be discriminated against on the job or anywhere else. It just said specified activities are illegal. And a lot of people said, well, that's a symbolic gesture of traditional values and so forth, but since we don't enforce it, it's not a big deal. But it was a big deal. It turned out to be a very big deal. It gave legislators, it gave judges, it gave police officers, it gave ordinary citizens a permission to discriminate against a class of people. So if I'm right about what happened that night in John Lawrence's apartment, and if John Lawrence is right, then what happened is four police officers walked into a private dwelling and arrested two men for doing nothing.
So we're going to silence all our cell phones, and then we're going to continue.
Okay.
And there's, in one place in your book, you write, and this I did write down, you said what your book is about is how gay civil rights lawyers rewrote a snarled human story as a pristine legal argument acceptable to a basically conservative Supreme Court. How gay civil rights lawyers rewrote a snarled human story as a pristine legal argument acceptable to a basically conservative Supreme Court. I thought that was an excellent summary of it. But one of the things that really drew me to the book was, as you know, as some in the room may know, I and certainly some of my colleagues have been part of the gay marriage debate in recent years. And one of the things that has often just I've grown weary of is sort of the white picket fence portrayal of gay and lesbian life, the idea that, and even some of the advocates will say, actually, gay parents are even better than straight parents. And sort of this, it seems to me, kind of overwrought attempt to portray gay and lesbian folks as just model citizens at all times. It's one of the reasons why I like the movie The Kids Are All Right, because I actually thought it portrayed the lesbian moms as interesting, real, complex characters who you could sympathize with and who had faults and all that. And I found that in your book as well, that this picture of a biracial, they weren't a couple, but two men, one black, one white, one older, one younger, neither of them with much social power, one of them in particular with very little social power. And then the milieu that they were in, including, I thought, your portraits of the arresting officers' own potential thoughts and feelings, and some race consciousness on the part of one of them, and their own fears, and what it's like maybe to be approaching an apartment where somebody says there's a crazy guy with a gun, in there. It was a very complex portrayal. How do you take? What's your reaction to this, the necessity here, apparently, of kind of cleaning up reality, making it all tidy in order to make an advance in the civil rights front? As David pointed out, and as you point out in your book, and as other media coverage has pointed out, in fact, John Lawrence and Tyrone Garner apparently were not even having sex. And yet they did not plead not guilty. They pleaded something else. Why did they do that?
Well, I mean, they were frankly advised that they had three options. They could plead not guilty, which is what they did the night after they were arrested, initially, and then you enter another plea later on. They could do that, and then they could insist on a trial and take this story in front of a jury and see who the jury believes. I think the jury would have found them not guilty. And in fact, probably would have laughed out of the jury box at the story that was told about what supposedly happened. So that was one option. That was not a very appealing option, certainly to the gay rights attorneys involved, because it might allow this couple, these two people, to escape false criminal charges, but it would not allow a challenge to the underlying injustice of the law.
Which had been upheld by the Supreme Court not long before this.
That's right. It had been upheld by the Supreme Court in 1986. And then the other two options were, one was to plead not guilty, to say we we contest, we do not contest the factual claims. We dispute the facts. We do not contest the factual claims. And then no contest, which is a slight version of the same thing of we're guilty, but we're going to challenge the law. The civil rights attorneys had before them, because there was not a trial, the civil rights attorneys and the prosecutors in Texas had before them only the 70-word, 69-word complaint filed by the officer that night. And that's all they had to do. They couldn't introduce facts from outside. They could not make factual allegations that were not in the record. So neither side, neither the prosecutors nor the gay rights attorneys had any interest in introducing any kind of extraneous facts. The police
like what
officers,
really happened or anything.
like what really happened.
Yeah, okay.
And this is not,
Yeah.
I mean, this happens all the time in American law. I mean,
Okay, I didn't know that.
the American system, it's a great question because most people don't know it.
Yeah.
We do not have, unlike Europe, we do not have an inquisitorial system of justice where an examiner, like a judge, examines all of the facts and attempts to arrive at the truth, the underlying truth. That is not the American criminal justice system. It's a system in which there are advocates on both sides, and a lot of procedural rights come into play. So it's a lot of people are surprised by this. It's a very common feature of American criminal law, and these civil rights advocates used it in the way that other people have used that same system to make a challenge to the underlying law as opposed to the facts themselves. And so it was in their interest to do it this way. They also ended up persuading Lawrence and Garner that there was a deeper cause here. And I think the reason Lawrence and Garner ultimately accepted that they should not just contest what the police had said, even though they did dispute it, not just do that, is that there had been a certain, I would say, assault on their dignity that night.
Like John Lawrence was dragged down the front steps of his home.
Exactly right. The police made according to him, the police made derogatory comments about him and about Tyrone being gay, called them names, used epithets associated with that. They had pushed him down onto his sofa. They had yelled at him. They were in his apartment, and he hadn't done anything wrong.
That seems to be what really stuck with him through all this, even after the case was won, that his apartment was entered by police officers who started abusing him, and that was the,
I mean, you can imagine this would be a reason to be a little upset
Pretty
from
angry.
his perspective.
Yeah.
And so, but he also, I think, was persuaded, as was Tyrone Garner, by the attorneys and by others, that there was a larger cause here, which they could help to make it the case that others in their position in the future were not treated in this way. So in a sense, my view is that the Texas so-called homosexual conduct law undermined itself. It taught a kind of zealotry to those who were enforcing it. And that very zealotry worked on the people who were arrested and caused them to fight back. It ultimately caused them to resent the way they were treated.
You have a nice passage where you talk about what Lawrence and Garner either did or did not have to lose.
Right. They were, I mean, these were not wealthy people. These were not highly educated people. They were not white picket fence people.
They didn't have children who they could lose custody of by coming out.
Right. They didn't have kids they could lose custody of. John Lawrence had some concerns about his job. Tyrone Garner had no job. He wasn't going to lose a job. He wasn't going to lose his social standing.
His parents were already, whatever his parents already thought about him was.
It was already
happened.
It was already out there, and I even asked him. I think at one point, and this is in the book as well. I said, you'd have to pay the, you'd have to pay the fine. He said, well, I didn't have the money to pay the fine. I mean, it was something as simple as that, and he had nothing to lose in challenges, and ultimately John Lawrence really didn't either, but they did have a potential. They were potentially going to be targets of a lot of media inquiry and a lot of criticism, and there was some of that, and they were willing to undergo that in order to fight for what they thought was the right thing in this case.
So how do we get from this apartment complex in Houston to the Supreme Court? You know, I guess we've got a few more minutes here, and there's a couple more things I want to do. But
Yeah.
I know you want to talk about you know, the oral arguments. What as the author of this book, as a constitutional law professor yourself, what jumps out at you about that was unique?
Yeah. Well, so once it got into the Texas courts, then it was a question, and there was a clean set of facts, the complaint by the officer. That was out of the way. Then it was a question of how you craft the legal arguments. And these really started in the lower Texas courts and then were refined as it went to the Supreme Court. But, and we could put this in very technical legal terms, which I will not do.
There are a couple people here who would understand it, but it
who
would be
would
lost on most
grasp
of us.
it,
Yeah.
right? But the basic claim was we have a right to privacy. We have a right to say that there is a limit to what the government can do in ordering our private lives. And that was one of them. The other one was whatever the government does to limit our privacy, it has to do even-handedly. So when Texas passed its homosexual conduct law in 1973, at the very same time, it decriminalized adultery. It decriminalized a crime that used to be called seduction on promise of marriage. There is no such law, I think, anymore anywhere, but it used to be a crime in Texas.
Well, I would think so as a woman, though.
You know, you could imagine it.
Yes.
And Texas, believe it or not, at the same time, it decriminalized sodomy for heterosexuals. All of the acts that homosexuals committed could be committed by heterosexuals in Texas with impunity.
Did they have a discussion about that in the legislature, or
Yes.
how did that, you know?
Yes, there was some discussion
Okay.
about it because there was discussion about, so they kept sodomy, and let me just mention this,
Yeah.
they decriminalized bestiality.
Really?
Yes. So all of those destinations down the slippery slope.
They went
that
ahead and
people
went
said,
there.
They went ahead and went there
That's interesting.
and just said, this is the only thing that we have to train our criminal
Well, that
law
does
on.
seem kind of unfair.
You could have, in other words, they were saying, you are prohibited from having intimate relationship with another person that you love, to whom you've dedicated your life, but a farm animal somewhere, we don't care.
Fair game, yeah.
Fair game. So that was done, and when it was proposed, when this Texas homosexual conduct law was passed in Texas and everything else was made legal, it was proposed that, well, shouldn't we give these people jail time? You know, and they're thinking almost entirely of men, not thinking of women. They said, shouldn't we give them jail time instead of just a $200 fine? And they said, well, we don't really want to give them jail time because that's not a punishment for a homosexual.
I remember reading that part in your book.
Homosexuals would like to be in prison.
So some very egregious things were said as part of this debate.
Right.
Yeah, yeah.
So what they did is they took these two arguments. We have a fundamental right to privacy, and whatever you're going to do to regulate people's lives, you have to more or less treat people equally. You can't just make it okay conduct for some people and not for others. And they said that those two arguments come under a larger narrative. Every case, every legal argument ultimately is it is about citing cases and technical points and so forth, but it's about telling a story. It's about a narrative. And the narrative that they told was, in striking down the Texas sodomy law, the court would not be leading the country anywhere. The court would be following the country. And for a basically conservative, cautious, and incremental court, that was an important narrative. That was a narrative that the court could accept. I think the court had learned some tough lessons from, say, Roe versus Wade when they struck down 50 abortion laws. All 50 abortion laws were called into question. By the time they decided Lawrence versus Texas in 2003, only 13 states still had sodomy laws. The other 37 had decriminalized it, either through legislatures or through courts, state courts. And of the 13 that still criminalized sodomy, only 4 of them, including Texas, did so solely for homosexuals. So the court was following the rest of the country, following a mainstream view that yes, whatever we think of what they do, people do have, there is some limit to the government's authority.
And only 12 years, or no, what, 15 years or so after Bowers versus Hardwick, where they said that those arguments were at best facetious. The court now in 2003 said the 1986 arguments were facetious. And they don't do that too often, right? Like say about their own court's previous.
That's exactly right. They said that that earlier decision upholding the Georgia sodomy law was wrong the day it was decided. Now that is as close as the Supreme Court ever comes to an apology. If you look back at, say, Brown versus Board of Education, which reversed a pro-racial segregation decision from 58 years before, the court didn't actually say that that earlier decision was wrong the very day it was decided. It said, we have come to appreciate over time that the meaning of equality in our society is such that you cannot segregate school children on the basis of their race. It's almost conceding that you could have seen the point back in the 19th century. This court said that earlier decision was wrong the day it was decided, and that was a very powerful moment in the Supreme Court.
Yeah, yeah. You know, when you first told, it was a couple years ago at a dinner when you and I were sitting beside each other and you told me this book you were writing, and I think as you recall, I immediately just thought, wow, that's a movie. You know, the way and he was, poor Dale, he was slogging through, you know, having his editor give him, you know, advice like emote, you know, and Dale's trying, okay, how do I emote more when I'm writing, you know. I felt pity for you, but I also, the way you told the story and the way you did your method here, you know, like you met John Lawrence and interviewed him and multiple times, and Tyrone Garner and the arresting officers and Paul Smith, who argued the case in the Supreme Court. John Lawrence is dead now. Tyrone Garner is dead now. Eubanks is dead now, the guy who called and made the charge about the guy going crazy with the gun. You know, you did something, nobody else really can do it, literally, because they're gone. And I could just see it cinematically, you know, that opening scene of, you know, stop, police, and the different versions, you know, being played out. And I said, wow, you know, the guy who made milk, you know, he should, you know, that guy should do it. And then the funniest thing happened in recent years. Since then, this was in kind of fall '09 that I learned about that. As you all know, kind of same-sex marriage continues to be debated. Prop 8 happened. And my colleague, David Blankenhorn, was a witness in the Prop 8 trial. And in the wake of that, Dustin Lance Black, who wrote Milk, wrote a play called 8, which has been read, there's been readings of it here in New York, and there's been readings in Los Angeles. Rob Reiner has played David Blankenhorn here in New York. In Los Angeles, John Riley played David. And early on, when you and I were talking about this, and I was emailing you one time and said, kind of jokingly, who should play the roles in the book, and I said John Lawrence should be played by John Riley. I said Eubanks should be played by Chris Cooper. One of the Lambda lawyers, I said Jane Lynch, perfect. You know, I had it all worked out. You know, and then to see John Riley playing my friend David in the 8 trial was quite funny. Well, the LA Times, and painful for some of us as well, the LA Times interviewed John Riley. He said, yeah, I basically did no research on this character. I don't even know what David Blankenhorn looks like. So that brings me to something that I wanted to say to the camera, which is that I would like to issue an invitation and actually a challenge to John Riley and Rob Reiner and all the actors who participated in 8 to come here to this space, the Center for Public Conversation in New York, and have a conversation with us. We're right here off Columbus Circle. We're not far from Broadway. You're here often. And I think we could have a really good conversation. And if they came, maybe you could come and join us at dinner, and you could tell Rob Reiner about your book, and he could make some phone calls. I mean, it would be a fun night, don't you think? Don't you think? So just let them know that a girl has challenged you to come here and meet with us. And I'm waiting. Our phone number, 212-246-3942. You know where we are. So thank you. Next thing I wanted to do, and then I'm going to open it up for the group. A friend of mine, also David, said, with regard to same-sex marriage, that in some ways we would be more American on the day that same-sex marriage became the law of the land. He said it in his book he wrote several years ago. He said it on the stand in Prop 8. It's been wildly misunderstood in the media as if he was somehow forced into saying that, when it's actually what he believes. with regard to Lawrence versus Texas, I do feel that we became more American on the day that Lawrence versus Texas became the law of the land. I felt that way anyway. Reading your book only convinced me more, especially once I understood how such laws criminalized a class of people. With regard to same-sex marriage, I do feel more of a tension there. A tension of rights versus rights. And it's something that you and I have talked about before. I know you're probably familiar with my argument, but on the one hand, very much understanding the argument about being excluded from an institution being damaging for persons excluded from it, that is, gays and lesbians excluded from the institution of marriage. And on the other hand, my concern about how redefining marriage redefines parenthood in ways that make it hard for us to say that children need their mother and father, or that children, whenever possible, have the right to know and be known by the parents who made them. A right which is actually articulated in international human rights law. As you know, the Convention on the Rights of the Child recognizes the right of the child to, whenever possible, be raised by the parents to whom they were born. As Margaret Somerville, a Canadian ethicist, pointed out, the Declaration of Human Rights articulates the right to marry and the right to found a family as a compound right. So when we talk about marriage, which you do some in this book and which you certainly have in the case, I think your big article was the traditionalist case for same-sex marriage. When we talk about marriage, we are talking about parenthood, and we are talking about how we understand parenthood. As someone who's written a book about a major civil rights case for gays and lesbians, and who's a civil rights law professor yourself, how do you respond to a tension that at least I and two other people, I think, in America see there between the rights of gays and lesbians, which are, I feel it, I believe I feel it, I do, and yet the rights not to efface and deny this bond and need that children feel to know where they come from and to be in relationship with those persons?
Well, I think a lot of things about that. One reaction is that I know that you and that David and others genuinely hold this view, and it's not out of hatred for gay men and lesbians. I know that. I'm convinced of that. And I'm convinced that one can hold this view out of a genuine concern about unintended consequences and a desire, to me, a very conservative Burkean desire to take things slowly, especially with an important social institution. I mean, I have a lot of sympathy for that argument, and it is, for me, it is precisely because I believe that the movement for same-sex marriage is the product of long-term shifts in American society, both in our treatment of gay men and lesbians and in the possibility of them raising their own children and being parents themselves and having the obligations of parents, and because of changes in marriage itself, that we come to this point where I think same-sex marriage is thinkable, and I think it's something that could be good, would be good for the people who get married, for the children that they're raising, in many cases, not all, and even a little bit for the institution of marriage itself. So I trust your good faith. I don't have any doubts about that. I think I see part of what the concern is. I have some of that, I've always had those kinds of concerns about any public policy issue, but in my mind they are resolved. They are being resolved and have been resolved toward recognition. And I think this book is not a book, as you know, about gay marriage. Right. I think you could read the book and come out in any number of ways on gay marriage, as you do. Mm-hmm. And it's not an argument really for gay marriage. It's a story of what happened in this case. It's a story of how people craft legal strategies to meet very serious human rights needs.
And yet it is also, when we're seeing on the near horizon likely another major Supreme Court case affecting civil rights for gay and lesbian persons, which would be around gay marriage.
That's right. And I will say one thing it does, I think one thing the case does, I don't know to what extent the book does it, but one thing that the case did was not so much arrive at the destination of same-sex marriage, if I can put it in those terms.
Mm-hmm. Like Scalia in his dissent said that it would.
Like Justice Scalia said in his dissent, he thought, you know, that there were no arguments left if you remove the moral concerns about homosexuality as were rejected in Lawrence versus Texas. But I don't think the decision necessarily arrives at the destination of same-sex marriage, but it removes a huge roadblock
of
on
saying
that path.
People who can't have sex with each other somehow can get married with each other.
It would be exceeding. It would be passing strange to say you have a right to marry a person that you have no right to be intimate with.
Yeah.
I think at the very least the case did get us to the point where we can talk about this issue without the overlay of the presumptive criminal status of gay men and lesbians.
Yeah. Some nations, kind of getting back to this parenthood thing for a minute, and then I'll open it up. Some nations, as you know, have banned anonymity in the sperm and egg trade. They've said that you're not allowed to deliberately create a child who does not know. But we're in New York, as you can tell, hearing out there. To create a child who will never know the identity of his father, for instance, or his mother in some cases. One of the things that I've wondered, when just thinking about legal responses to all this, is if same-sex marriage is happening in a number of states, it's going to be before us nationally sooner or later. It's going to be a cultural conversation for quite some time. If we could somehow strengthen the move towards eliminating anonymity as part of this practice in the U.S. Most people who procure sperm or eggs in order to have children via third-party donors in the U.S. want an anonymous donor, in part because they don't want, whether it's a lesbian couple or a single mom or a heterosexual couple, they don't want that biological father involved. Do you have an opinion on anonymity or some?
I have. That is not an issue that I have.
Yeah.
I have researched, and I have to say I just don't feel like I know enough about it, that I've done enough research to have a view. That, of course, doesn't stop me from expressing a view.
Okay, good,
And
good.
I should say I don't have an informed view. And I guess my immediate reaction is that it would seem to me that that is genuinely a clash of I think David has called it a conflict of goods. That this does seem like one. It does not seem to me that issue is an issue that the question of same-sex marriage resolves either way. In other words, I think you could be an advocate for same-sex marriage and either support this proposal or not support this proposal. And by the same token, you could be an opponent of same-sex marriage and either support this proposal or not support this proposal. That's probably as much as I should say before I get myself in a lot of
territory.
Before I go too far beyond what I've written here.
Yeah, I'm waiting for some courts to take this up in our country. This week, the Supreme Court actually did visit the issue of conception via sperm donation in the case of twins who were conceived posthumously with their father's sperm years after he died, and the twins' mother now wants Social Security survivor benefits for the twins. And so we have this, to me, very peculiar situation of the justices mulling over whether the state should lay out some thousands of dollars in survivor benefits for these children, when the issues to me are so much larger than that, so much more at stake. But perhaps soon. Thank you for allowing me to digress a bit like that.